Welcome to our Supreme Court decisions. There are so many exciting decisions that we're coming with in 2020 from the June decisions put forward by the United States Supreme Court. Today's decision that we're going to discuss is Chiafalo versus Washington, and the discussion about selecting and making choices for the Electoral College. So we begin with the 2016 election between Donald Trump and Hillary Clinton. And let's talk about the history about this case. So the state of Washington, like any other state, has electors who are chosen, and usually the numbers work by you take the numbers of the members of the Senate and the members of the House of Representatives, and that tells you the amount of electors that are for that state, and usually it's decided, as we will discuss, by the popular vote, and then the electors follow the popular vote. So the state was won by the Democrats, state of Washington, and 3 Democratic electors voted, instead of Hillary Clinton, voted for Colin Powell. Why did they do this? They claimed that they wanted other Republican electors, and we'll discuss how that's sort of set up, to move away from Donald Trump. So they felt that they wanted to show that this is possible. So we're going to take our votes away for Hillary Clinton. And this way, other electors would be sort of convinced, and they would deprive Donald Trump with the 270 electors required to become the president. And therefore, if you don't have that amount, if you're less than 270, then it goes into the House of Representatives, and they would make particularly that decision. It's kind of fascinating. At that time, actually, the House of Representatives were actually with the Republicans. So maybe they were hoping or thought that maybe there would be another candidate that would be chosen instead of Donald Trump. So actually what the state did is the state fined each of these 3 electors, Chiafalo, Guerrera, and John, $1,000 apiece. The electors claim that they can vote for whoever they pleased, and we'll discuss a little bit of the history around the Electoral College. So they felt that they should have the right to do so. It doesn't matter what the popular vote is. The Court of Washington said, based upon Article 2, which we'll discuss, which is the article that deals with the presidency, gives broad authority to the states to make that particular decision. And nothing in the Constitution gives the electors any discretion to choose who they want to be president. They just have to follow, as we'll explain, what the state requires. The fact is that a few months later, a case was brought forward from Colorado, a person named Michael Baca, who, again, a state which was won by Hillary Clinton in 2016, and he decided to vote, instead, one of his votes not to go to Hillary Clinton, but to go to John Kasich, who was the governor, I think he was still the governor at the time of Ohio, who was also on the Republican ticket, at least in the primaries. And actually, this went up the court system in Colorado to the 10th Circuit. And they said that, because what happened was Michael Baca voted, they took him off the slot, they put another elector to vote for Hillary Clinton, and when it went through the courts, they said that no, that he had the right to vote for anybody he wanted, and it was not illegal for him to do so, and therefore Colorado did incorrectly. And then it went to the United States Supreme Court. So it came to the United States Supreme Court because the court decided, especially since there was a dispute between the 2 different courts, to try to deal to the constitutional issue here, and that is the question of whether or not an elector, can he decide, or can she decide on her own to vote for whoever they please, even if the popular vote or the state says not to vote that particular way. So just before we get to the history a little bit of it, the way it was set up, and the way it's set up today, is that, and we'll get to, again, explaining within the Constitution how we choose a president, because we're all taking the assumption here that we choose the president by popular vote. That's almost correct, but not 100% correct, as we'll explain. But the way it works is that if you have in a state, let's say the popular vote goes for a candidate from the Democratic Party or goes for the Republican Party, most states will have a list of electors from each party, and then if that state wins for the Democrats, so they'll take the political party, the Democratic electors, they will follow whatever the state requires, and they will cast their vote for that candidate. And if the Republican Party wins that state, they do actually the same thing. So just first of all, and as we'll discuss the history, there was a case between Ray versus Blair in 1952, where the court said that states require or may require an elector to take a pledge in advance to support the nominee that is actually going to be chosen by the state. So they have to take a pledge before that, and in 1952 that was ruled as constitutional. We'll discuss a little bit about that case, which also has an interesting history with regards to the elections in 1948 and 1952, with regards a little bit with segregation and all, which we'll discuss. And here the issue for today of the court was whether or not whether a state could penalize an elector for breaking that pledge. So that was the issue. So the issue of the pledge itself, which again we'll discuss because those in Chiafalo and others perhaps are saying that that's also incorrect, an incorrect ruling in 1952. But again, the main point brought forth by the court is whether or not we can penalize an individual for violating the pledge and voting against the will of the people. Let's discuss a little about the history of the Electoral College. How do we pick a president? So this was a late decision in the convention of how to actually come forward and decide how we should choose actually our president. This was the United States of America, that there are many states, and they came to a decision and a concern of they didn't want greater states to take advantage of states that were smaller, and how to actually work this all together. So many of you know how this works in civics. You probably learned younger, is that what you do is you have each state, first of all, has 2 senators. So even if you're the smallest state or a small state like Rhode Island or Delaware, or you're a big state like California or Texas, that you actually have 2 senators. And then you have, based upon population, House of Representatives. So the bigger states have more individuals in the House than the smaller states. So for example, you can have a state that has 2 senators and only 1 person in the House of Representatives. That's actually possible. States like Wyoming are similar to that. That only have 3. They have 2 senators and 1 individual in the House of Representatives. So now the question is, so what happens is that, okay, so let's say usually the way it works is that it was set up that on some level, some of the framers, Hamilton and Jays will discuss, felt that perhaps the presidency should not be sort of chosen by the people. Should it be chosen by for example, should it show by the legislature? Should it be chosen by the people? So they came up to this idea that it would be chosen by these electors. So let's understand what their power was. So again, an elector was an individual who was not a member of the Senate or the House, and the old clause would say the following, that the elector had 2 choices for president, and so they would put two choices for who they thought would be a proper president, and then they would count up the tally, and therefore the one who was at first would be president, and the one who was a runner-up would be the vice president. So early on, this sort of had a little bit of a problem, because in 1796 already, John Adams, who was a member of the Federalist Party, before there wasn't really parties per se, really started building during the time of Washington. They called themselves Federalists, and what they called the Democratic Party, Democratic Republican Party, was really the Jeffersonian and Madison Party, and therefore there was a majority for Adams, and came in second was Jefferson, and therefore that's sort of what happened. So Jefferson became the vice president, and Adams became the president, and there was tension between the two of them. They really didn't work that much together. Now in 1800, this became even worse because what happened was it was sort of understood that you were going to be a little more broader. You were going to vote maybe for somebody else from a different party or a different thought process. But what happened was that the Democratic Republican Party put forward Thomas Jefferson as well as Aaron Burr. And what happened is that they had a complete tie. They had thought that Jefferson would be president, Burr would be vice president, but now with exactly a sort of this tie, it had to go to the House. It became a whole hoopla until basically they decided to make Jefferson president and then Aaron Burr vice president. Now, the result of this issue was they came up with the 12th Amendment, which said no longer are you making two choices for president and therefore the runner-up will be the vice president, but there will be a list for presidents and then there'll be a list for vice presidents, and that was enacted in 1804. So the amendment brought to line the concept of there are political parties and people are going to sort of lead or lean to their parties, and therefore this will solve the problem of having sort of this tie that continuously would happen. For the first few decades, the state legislators picked the electors, but by 1832, all states but one introduced popular presidential elections. So therefore what happened was by 1832, the electors would be chosen by whoever would win in the popular vote. So again, this would again set up a situation where you'd have two lines of electors, one or maybe even more if you had more parties, that each electors would be following particularly the party or what really came forward in the presidential election of that particular state. And even and they used to have, not in our day, but they used to have in the early, even till about the early 20th century, you would have the names of the electors when you went to vote. So that already stopped because no one really took seriously again who the electors were. So in the 20th century, many states enacted states' requirements. You had, for example, 32 states in DC today have a pledge that required by law to vote for that particular person. Just to mention that the states of Georgia, Texas, New York, and Idaho, just to name a few, do not have a requirement for the electors to have a pledge. Maybe understood that they would vote that way. And 60 years ago, they started creating what we call sanctions. For the 15 states have a system that's set up that they could remove the elector and also require a penalty for violating particularly their pledge. And Washington is one of those 15 states. Let's talk a little bit about the pledge requirement first. This was the case in Alabama in the primaries of 1952. Let's talk a little bit about history of Alabama. In 1948, in the presidential election of the Democratic Party chose Harry Truman. Harry Truman basically desegregated the military, and there was a lot of uproar in the South for that. And basically they went with, at the time, I believe he was a senator at the time, or the governor at the time was Strom Thurmond. Strom Thurmond led this party, and it seemed that in 1948 there was tension between what maybe some electors felt that they wanted to put in Harry Truman, even though the state was really pushing for Strom Thurmond. This also came up in the primaries of 1952, a little more complicated, just because Harry Truman was thinking of running for president for, it would be his second term. It was close to a third term, and there was a lot of tension. And in the case of Ray versus Blair, the fact was that most of the decisions of electors were decided at the primaries because it was extremely difficult. The reality was without the Civil Rights Act, blacks were sort of, basically, they understood through history that they were not to go and vote. There was a lot of pressure on them not to vote, so there would be no chance of a Republican winning in the South. So basically the choice of who would be the president really decided by in the primaries. So basically there was a pledge requirement, and the issue brought forward from at least this person, Ray, was that it interfered with the best judgment of the elector. And the court decided, and we'll discuss this a little bit further, that the Article 2 of Section 1 of the Constitution, as well as the 12th Amendment, doesn't prohibit states from appointing electors they want, and basically they have a right to choose those electors, and that the custom was that that they would vote a certain way, and that there was no mention of, particularly, as we'll discuss, of the electors having a choice. So the fact was that Ray left open, because there was no discussion there about can he be fined. The only question was, can they really get rid of him and put another person in? So the issue here in our discussion is whether or not a fine would violate the elector's constitutional freedom to vote as they choose. Let's discuss a little bit about Article 2 and giving states the rights to choose electors. So again, the beginning of the beginning of Article 2 is really discussing the presidential powers, but again, the first section it's a long part of the section, deals with how we actually choose a president. And we went through that a little bit about members of the Senate, members of the House. So we went particularly through that and really discussing the issue of whether or not, when we say that electors vote, do they have a right to make those choices? Meaning, does vote really mean I have a choice for who I vote? So first of all, Article 2, Section 1 speaks about the following. It says, how do you choose electors? In such a manner as legislature thereof may direct. So therefore, it implies within Article 2 that not only is the manner of who you can choose, but the question, first of all, is that there's great discretion to obligate the elector. So Article 2 gives a lot of room to the states to basically say, elector, you do what we want. Nothing actually prohibits the states from taking that elector away or taking power of decision away from that elector. The only thing that the states cannot do is they cannot appoint a senator or a member from the House of Representatives or any other member of the federal government, particularly for that point. But the electors argue that Article 2 says the following, that it says we may vote and we may have a ballot, and that requires some level of freedom. So the question is that argument correct? So Justice Kagan, for the overwhelming majority of the court, as we'll mention that all 9 justices will rule in favor of the state, 8 of them for one reason and 1 for another, but basically the question is, Justice Kagan, who writes for the court, says that a vote doesn't always connote independence. Many times a person might be following their spouse or their pastor, and it could be just mechanical. That's an interesting question, because the fact is they're still making a decision, you hope. But she says, for example, take this old Soviet Union. Yes, you had a right to vote, but you only had one person to vote for. That was still technically considered a vote. Voting is still voting when discretion departs. The fact is that the electors still elect the president. Now, the question is, there were some framers, the whole purpose of the electors was that they wanted enlightened and responsible citizens to have discretion to decide who the president should be. This was actually the thoughts of Hamilton and Jay, even those who wrote the Federalist Papers, that the fact is that it was always understood, well, the electors, they perhaps they wouldn't be sort of enraged or sort of affected by sort of the passions of the people, and that's actually why the framers felt that it was necessary to have the House, the Senate. They created this checks and balances, that it would not be just for the fervor of the people to do X, Y, and Z. They would have people sort of behind and sort of thinking about it, very similar to the way in England you have the House of Commons and the House of Lords. But the fact is that Justice Kagan points out that they didn't write it in the Constitution, that they left it much up to the future. And it's questionable whether or not, in essence, we really wanted the electors, did they have to be the ones who made the decision? The first thing that the court said is that there's nothing explicit in the Constitution that says that the electors have the discretion. The second thing is that we look at long settled and established practice have a great weight in proper interpretation of Constitution provisions. And the fact was, if you look at the history, number one, usually the pledge was for the party. So everyone pledged or basically understood that the person were voting first for the party, not for their own discretion perhaps, even though they perhaps followed the party's line. And we know the problems that existed in 1796 and 1800, and with the 12th Amendment, it made sort of knowing that we would not have a fault where someone would go off the party line. Ray, which is again a case in 1952, allowed votes for the regular party, was on the ticket, and it would file, and that you had to follow the desires of the people. That already was coming forward in the popular vote. Even Justice Story in the 19th century that really said there's nothing left to the electors but to register votes which are already pledged. So basically it's a sort of a perfunctory thing, that they actually are going to just go through the votes in that particular way. And we've seen that states' practices have evolved, that they even stopped listing the electors on ballots. And statutes really developed in a way not to allow free agents to make their own decisions. So what we're seeing here is, and just we'll talk more about this a little later, is that the purpose for the electors is probably to really set the stage and allow each state to sort of be represented and allow smaller states to have somewhat of a more representation percentage-wise under certain circumstances, and that might be one of the main purposes of the electors. So the electors themselves, in this case his name is Chiafalo, and others said, wait a minute, let's look at the history. I always sort of keen on this is finding it after, the way the electors work is that you have the election, and basically whoever wins the popular vote, and hopefully you get to know it sooner than later. Some elections don't really work that way, but most do. You basically know it that night, or sometimes even just the next day. We know what happened in 2000, a little bit longer. But the fact is that in December, sort of the electors take that information, then it's read by the president of the Senate, and sometimes you find, like we had in this previous election, you had 7 electors who went sort of and voted for different people. So they stressed that there have been 180 faithless votes for president and vice president. So over time, there have been 180 who decided not to vote that way. But the truth is, as pointed out by the court, there's been 23,000. So you're talking about a percentage of 0.78% of people who sort of went a little off and decided to vote differently. And most of those actually occurred in 1872, when Horace Greeley, who's very known famously as a abolitionist writer in New York, went for a party called the Liberal Republicans. Kind of fascinating history about where he went with this, where they basically went away from Grant and tried to sort of make sort of peace with the segregationists. Basically, I don't think they were called the segregationists at the time, but the fact is with the South, and he died after the election. So what do you do with his electoral counts? So some of those were changed. You don't really vote for somebody who's dead, but the fact is that these were tolerated. This was not something that was considered the norm. And basically, these never came close to changing the election. So just like even the election 2016, these were sort of protest or whatever, anything like that. It wasn't really meant to really change anything. And the fact is, the electors said, well, Congress basically didn't do anything about it, right? Or basically they should do something about it. But the fact is that they've given deference to the states. There's no ground for rejecting a state who doesn't penalize such situations. So basically the court decided that you can have these fines, that it's based on Article 2 and the 12th Amendment, and there's broad understanding of the Article 2 to allow states to particularly make their decisions and tell the electors, you must follow us or else. Let me just give a moment again to Justice Thomas, as we would say in Hebrew, Darka B'Kodesh. I mean, he usually has a different understanding of the Constitution, and basically he concurred in judgment. Justice Gorsuch perhaps agrees with some of what he says. I think the main thing that I wanted to share from Justice Thomas is that he says that there is nothing in Article 2 that speaks at all to this issue, basically. And the fact is that we don't know if Article 2 gives any information, doesn't give any information, he says, with regards to how the electors should vote or what the states can do. He basically falls back to the 10th Amendment, which is the amendment of that anything that was not given to the federal government is left for the states, and he basically says it's left for the states, and therefore doesn't read as broadly Article 2, so therefore he concurs in judgment, and the fact is that all 9 justices agree that the states have a right to tell the electors what to do. In conclusion, I wanted to read the end of the decision by the majority of the court and then sort of give you as well some of my thoughts about this decision. The elector's constitutional claim has neither text nor history on its side. Article 2 and the 12th Amendment give states broad power over electors and give electors themselves no rights. Early in our history, states decided to tie electors to the presidential choices of others, whether legislatures or citizens, except that legislatures no longer play a role. That practice has continued for more than 200 years. Among the devices states have long used to achieve their objective are pledge laws designed to impress on electors their role as agents of others. A state follows in the same tradition if, like Washington, it chooses to sanction an elector for breaching his promise, then the state instructs its electors that they have no ground for reversing the vote of millions of its citizens. That direction accords with the Constitution as well as with the trust of the nation that here we the people rule. And therefore the court rules in favor of the state of Washington that they may not change particularly the will of the people. First, I want to say it's fascinating that in 2020 we're still discussing something that was written in the Constitution dealing with something so fundamental, the choosing of a president and that of the electors. I want to just share some of my thoughts about this and thinking about particularly the importance of the electors, or perhaps not, for those others who feel that it should just follow the popular vote. I think here the United States basically still seeing itself as 50 states, I mean it wasn't 50 states when it started, really wanted to make sure that smaller states still would have some level of even greater representation so that bigger states would not envelop smaller states. This has always been a tension over time, over us understanding what is the United States of America. There is no doubt that there's a much more flowing of information, and there's much more in common between states because of the media we watch and sort of the mass communication that goes from one to another. But many times there are issues that states, and particular states, have concerns of that might not be the concerns of other states, and therefore there is an understanding of this is not a democracy but a republic, and therefore we have a situation where minority can be somewhat protected. I mean, not broadly protected, but minorities can be partly protected under this system of the Constitution. I do think that the court is correct to say that electors are basically agents. I think it's a great way of putting it. I think that through time we've understood that it is better to allow the popular vote to make these particular decisions, but the fact is that it would be decided and it would be structured within the concept of each state sort of giving its popular vote and bringing forth its it's electors. The fact is, whether Justice Thomas is correct here with regards to whether this is only through the 10th Amendment, it's hard to not read that Article 2 gives tremendous discretion to the states to do what they want with it. It's sort of kind of hard to really understand Justice Thomas's case. Maybe I should need to read a little bit more, but the fact is that yes, obviously if it wasn't given over, it's still given over to the states, but it seems to me it was an integral part of Article 2 that the states would be the ones who would decide who should be the president. They would make those decisions. It would come from whatever way that the states felt that was necessary, and they would come forward. So again, people might dispute this issue of the electors and how it should work. I think it's something very unique within understanding of jurisprudence here in the United States of America.